Madam Clerk, would you open the courtroom for us, please?
The State of Michigan 36th District Court is now in session with the Honorable David S. Robinson Jr. presiding. Good morning, Your Honor. Good morning, everyone.
Good morning.
Good morning.
Fix it. Good morning.
Good morning.
I'm waiting for your opponent to connect up.
Okay.
All right. Should be here now. All right. We are on the record. This is case number 22-198831. Allied Financial Incorporated versus Willardine Houston. This appears to be our second pretrial. Your appearance.
Yes, thank you, Judge. This is Natasha Dixon on behalf of the plaintiff. My fee number is 82333.
Good morning, Judge. Good morning, Attorney Dixon. I'm Attorney Steve Reyna, P number 42423, and I'm appearing on behalf of Willardine Houston. I'm going to apologize to court and counsel. I spent the last week and the weekend in bed, so I'm not 100% right now, so I apologize.
Don't take your time, counsel. It's a marathon. It ain't a sprint.
Thank you, Judge.
We were last together on the file. The court opened your written discovery. How are we doing on that?
Judge, we have received the documents that Mr. Reyna provided that we did discuss last time. My client is currently reviewing those, the insurance papers, the letter that he provided. I have sent a follow-up to them saying, if they have a, response to that, but they are still reviewing that, Judge. So of course, as soon as I have that, I'll reach out to Mr. Reyna for that and see what my client is saying.
All right. Well, let's do this then. Let's continue your written discovery.
Okay.
Let's give you a return date. That would be June 27 at 10 o'clock. Does that work for everybody? It's a Tuesday like today.
Yes, thank
Judge,
you.
I'm confirming that. I'm confirmed, Your Honor.
Okay. June 27 at 10 o'clock. We'll continue your written discovery. Is there anything else we can accomplish today?
No, Judge.
Again, I thank the court and counsel for their gracious understanding. And I look forward to seeing you guys next month.
Okay. Let's get rolling.
All right, thank you.
Mr. Reyna,
Thank you, Judge.
health is a true wealth.
Thank you, Judge.
Feel
I'm
better.
finding that out.
All right, y'all be safe.
All right,
All right,
thank you,
thanks,
Judge.
Judge.
Good morning, ma'am. What is your name?
Good morning. My name is Janae Lindsay.
Ms. Francis, good morning.
Good morning, Your Honor.
We are on the record. We are calling file number 221983888, Woodbridge Estate Apartments versus Janae Lindsay, date and time for pretrial. Appearances, please.
Good morning, Your Honor. Nafjat Francis on behalf of Plaintiff's Attorney of Record P72322.
And your name is, ma'am? Ma'am, your name again? Are you Janae Lindsay?
Yes, I am.
Okay, we were last together on this file on the 10th, I'm sorry, the 2nd of May. And at that time, the court closed your written discovery. Since that time, a motion for summary disposition has been filed on behalf of the plaintiff. Have you guys settled this case?
No, is there any way we could do a motion to dismiss, or because I don't know what I owe. I don't know. This is really holding me up. I moved a year ago. I'm trying to move again. My baby about to graduate 5th grade. I'm staying with somebody. I told them I needed a year. It's been a year, and then I got served with some papers. My baby do virtual because I didn't know where I was gonna stay for him even to go to a school. This is this on my name. I can't even move nowhere else. And I stayed at Woodbridge for 3 years, and y'all really want me to pay $7,000 for 4 months in the middle of a pandemic, and the judge dismissed my case. Everything that they suing me for, the last attorney that took me to court, he said it was fine. The mattress that they suing me for, he told me it was okay because they didn't have nowhere for me to put it, and they didn't want me to mess up the community, just put it landing by the trash can. They told me it was all right. It was just a mattress, not a box spring, nothing, just a mattress. I don't have $7,000, but this is really turned my life upside down.
Well, let's make sure, ma'am, that you have an opportunity to file a written response to the motion for summary disposition.
Okay.
And so that's going to be a file. You must file and serve that in accord with the court rules. You file and serve a copy on the plaintiff's lawyer. You serve a copy of the answer to the summary motion for summary disposition on the court. We will calendar this motion for June 27th at 10 o'clock.
So I need to put can I write that down 1 second so I know what to do. You said I need to write a motion to the court and
No, you're writing an answer to the motion for summary disposition. And you have to serve a copy of your answer with the court, a copy of your answer to the plaintiff's lawyer.
in Your Honor, I'm answering to them saying that I owe them.
Ma'am, you're responding to their motion for summary disposition. Yes, ma'am.
Okay.
And the motion will be heard on June 27th at 10 o'clock. Is there anything else we can do today?
No.
No, Your Honor. Thank you.
Okay. We'll send out the order today. Thank you both for coming in. Let's be safe out there.
Thank you.
Thank you.
I already suspect.
Hello,
Hello,
what is your name?
Miko Polk.
All right, we can get started in just a second here.
Okay.
Hello.
All right, we are on the record calling file number 22-192478, Discover Bank versus Tamika Polk. Date and time for a motion for summary disposition on behalf of the plaintiff. Appearances.
Good morning, Your Honor. For the record, William Saloom, appearing on behalf of plaintiff P411487.
Your name, ma'am?
Tamiko Polk.
Counsel, your motion.
Yes, Your Honor, this is plaintiff's motion for summary disposition based upon MCR 2.116C10. We're stating to the court that there's no tribal issue. Defendant in her responsive pleading acknowledged the allegations in plaintiff's complaint, has not stated a tribal issue. Therefore, as a matter of law, we're asking the court to grant judgment. Attached to the motion should be an affidavit of account stated indicating the amount plaintiff is sued for.
Ms. Polk, what is your response?
I am currently unemployed and I don't have any funds to pay anyone at the moment.
Is the court has received your written answer to the motion. Is there anything else you want to add?
No, just the fact
All right.
that I don't have any, go ahead. That's it.
No. I wanted you to say whatever you want to say on the record.
That I don't have, I had a work injury and I've been down. I have it's not a noted disability, but I've been in pain ever since I've had a knee injury at my job. So it doesn't allow me to work at the moment.
All right.
So I'm currently looking for work.
All right, the court is prepared to rule on this motion on MCR 2.116C10. The court is required in a claim that there is no genuine issue of material fact to be liberal in finding the existence of a genuine fact for trial. However, the court is also bound by MCR 2.116G4. A motion under subrule C10 must specifically identify the issues as to which the moving parties believe there is no genuine issue as to any material fact. When a motion under subrule C10 is made and supported as provided in this rule, an adverse party may not rest upon the mere allegations or denials of his or her pleadings, but must, by affidavits or otherwise provided in this rule, set forth specific facts showing that there's a genuine issue for trial. If the adverse party does not so respond, judgment, if appropriate, shall be entered against him or her. In this case, the motion for summary disposition is supported by an affidavit of a Patricia Glover describing the account and the outstanding balance due on the account. The defendant did file an answer. However, the answer is not supported by the affidavit. Therefore, under MCR 2.116C4, it is insufficient. The motion for summary disposition must therefore be granted. I recognize that the defendant is indicating that she's having financial hardships, but financial hardship is not a valid legal basis as a defense to a motion under MCR 2.116C10. The motion under MCR 2.116C10 is therefore granted. Counsel, you will submit your order under your proposed judgment under the 7-day rule, along with your SCAR status report. Ms. Polk, you have an absolute right to appeal my decision. That appeal must be perfected in 21 days of the date that the judgment is entered. Thank you both for coming in.
Thank you, Your Honor. Your Honor, we'll submit it by notice of presentment under the 7-day rule then.
I'll be here.
Thank you, Judge. Have a good day.
You too, sir.
And Ms. Polk, have a good day as well. Thank you.
But some boat stuck out his tongue. But something sneezed. Said Signor Pizzicato. Tubby, I've never heard a tuba play a melody before. Let's hear the rest. Oh, said Tubby. I have never done wonderful such things. Having releasing your children. Oh, people. Well, we've done it, haven't we, Johnny? It was the bullfrog sitting right beside him. We all have our complaints, don't we? Oh, thought Cubby, how happy I am. WRCJ FM on Tuba Tuesday, Tubby the Tuba. The George Kleinsinger music with the story by Paul Tripp. Stephen Fry of that narration from the 1945 score, which became a film in 1975, starring Dick Van Dyke, Pearl Bailey, Jane Powell, Miami Bingo, Jack Gifford, David Wayne. With the 1975 movie. We just heard Well Philharmonic with Harry Wordsworth. WRCJ FM, HD1 Detroit. WRCJ is supported by the Palmer Park Art Fair, featuring jury and emerging artists, music, dance, storytellers, and food trucks. Palmer Park is around Woodland, south of 7 Mile, free parking, free admission. This weekend, palmerparkartfair.com. Jan Zelenka in the 2 spot of today's midday music show. Here's Camerata Baron. This is supported by WRCJ.
Something she has, it sounds like it does. This is no case. We are on the record calling file number 22200294, American Specialty Pharmacy Care Plus versus City of Detroit. We were last together on this file on May 2nd, 2023. At that time, the parties in the court agreed to today's date, May 30th at 10 o'clock for the next pretrial. Now, wait, somebody's coming in here. Let's see who this is. Hello? Hello?
Hello, good morning, Judge Robinson.
What is your name?
Tria Brown.
What brings you here today, ma'am?
I have a case today. The case number is 222-43752, Tria Brown against Marsh and Sassy Monument and Memorials by Marsh and Sassy.
Okay, that matter's not scheduled till 11 o'clock. And I believe the matter's been taken off the docket. Can you give me that number again, please?
Sure.
Wait, hang on for just a second.
Okay.
Hello? Okay, have the file brought back up. What time was you scheduled? Okay, and on that May 2nd, what time was you scheduled? That's what I thought. Okay, thank you. Bye-bye. All right, Ms. Brown, the case was scheduled, last time it was scheduled on May 2nd, and that was at 11 o'clock. We seem to have a scheduling error on the file. So what I'll have to do is I'll have to have the file brought up, and I'll send out a new date for everybody.
Okay, yeah, the last time we met, I think it was scheduled for today at 11 because Attorney Adams stated that he was going to file a motion to dismiss.
But an attorney cannot be in small claims. This is a de novo, but it's still small claims. See, I made an error. That's why I sent you out that notice that I had stricken Mr. Adams' appearance because attorneys cannot appear in small claims. So we'll have to send out a new date.
I just want to make certain that I have this clear and understood. I did file an appeal and then it went to civil. And because I was taking a LLC or a business to civil, that's why the business needed to get an attorney.
No, that was an error on my part. I
Oh,
thought
okay.
the case was removed. I did not realize it was an appeal. A removal is a different thing than a appeal. Appeal of a small claims decision is de novo, but it is still a small claims case.
Okay.
The lawyers are not permitted in small claims. So we'll send out, I have the file brought up, we'll send out a new date.
Okay. Well, thank you. I appreciate it, Judge Robinson.
Yes, ma'am.
All right. Have a nice one.
Be safe.
You too. Bye-bye.
Thank you. All right, we are back on the record recalling file number 222000294, American Specialty Pharmacy versus City of Detroit. This matter is scheduled for pretrial at 10 o'clock. Neither party having appeared at 10:35, the matter dismissed without prejudice. Court will send out an order today. All right, that's gonna shut that down.
Fort Hanson's 1922 Nordic Symphony. Some of his most straightforward but powerfully expressive music. His first symphony. We heard the Eastern Rochester Philharmonic for every voice in the game all the time. What a home base of Howard Hanson, long time. And
Morning, Your Honor.
All right. All right, let's call file number 23-140446. Javon Burt, Edipong Agapan, and Anaya Amuchi versus Banyan Property Management. We have a motion for default judgment filed on behalf of the plaintiff. And we have a motion to compel discovery filed on behalf of our defendants. Could I have your appearances, please? Agapan and Anaya Amuchi versus Banyan.
Yes, this is Nanaya.
Filed on behalf.
I think somebody's video's on. But Nanaya Amuchi on behalf of the plaintiffs. And just for the record, Your Honor, we submitted 3 motions. So we also did a motion for deemed request admitted, and then also protective order, and well, that's included in the deemed admitted, and then the default judgment. Thank you.
Appearances.
Hi, my name is Davon Burt. She, her, theirs pronouns.
Thank you. Your appearance. Plaintiff.
Young Adiakman, she, her pronouns.
Thank you. Counsel.
Good morning, Your Honor. Aaron Cox, P69346. I'm appearing on behalf of the defendant counter plaintiffs.
All right, let us commence with the motion for default judgment filed on behalf of our plaintiffs.
Yes, Your Honor. We filed a motion for default judgment. Prior to that, we filed a notice and a motion to deemed the request to admissions admitted due to the fact that the last time we were here, we went on record and all parties believed that the discovery was satisfied. At the time on May 2nd, the defendant had still not filed a response to our request for admissions. And so at that last hearing, we informed the court that we would be filing the motion to deem admitted. And so based on that, we are also asking the court to move in favor of default judgment according to MCR 2.603, and which says a party may be found in default for either failing to plead or answer or for improper conduct such as discovery abuses, which is also quoted in Kalamazoo Oil Corporation v. Bowerman 242 Michigan Appeals 7587 2000. And we hope that you will enter into that today.
Mr. Cox.
Your Honor, I'm going to address first the issue being raised about whether or not my client has deemed admitted responses to requests to admit. I'm not sure whether or not the court has that before it today, but I think it's appropriate to address based on the argument made by the plaintiff here. Our responses were timely served on April 19th, 2023. Those were served by first class mail and pursuant to the court rules MCR 2.107. That service was complete the second that we put that document in the mail and sent it to the plaintiff. What the plaintiff has alleged in their motion is that because that document was not received by the court by that date, that somehow the responses just don't matter, and that's just simply not true. MCR 2.312 subsection B subsection 1 very clearly states that the matters are deemed admitted unless and until a response is, quote, served upon the requesting party within that 28-day time period. The plaintiffs in this case were certainly served with those responses in writing by mail on April the 19th. So there are no admissions that are admitted. But even if there were, Judge, MCR 2.603 is not a vehicle upon which this court can grant the default for that alleged failure. MCR 2.603 is a court rule that very clearly says that if a party does not appear or defend that a default would be appropriate. Well, clearly, Your Honor, we have appeared, we have defended throughout the entire course of the case. And while certain segments of 2.603 would permit the court to enter defaults for like not appearing for a hearing or a trial, that's not what we have here. They're simply alleging wrongly that admissions were admitted and therefore a default is appropriate. That's not contemplated by MCR 2.603 and the court should deny the motion.
Let me hear from plaintiff. What is the day that your admissions were served?
Yes, so our first written discovery was.
No, ma'am, I'm asking for, sorry, plaintiff, I'm asking for the date of the request for admissions.
That we sent to the defendant.
Yes, counsel. Yes, plaintiff, yes.
Yes, so we sent our first written discovery on March 28th.
On March 28th.
Yes, and so.
He has 28 days from that day, right?
Right, so that was until April 25th to respond. And to this day, again, the court has not received an actual, like we haven't received it and the court has not received it. And in all of our documents, we always file a proof of service to ensure that we have the evidence before the court. There has not been any proof of filing served on the defendant's behalf. And even at the last hearing, the defendant said that they were satisfied with discovery, even at the time when we raised that still in the record, there had not been any response to our request. And to this day, there still have not been any response to our request filed before this court. Aaron Daniel.
Let me stop you right there.
Okay.
Mr. Cox?
Your Honor, we do in fact have a certificate of service on the document that was sent to them. I personally put the document in the envelope and posted it on April the 19th to the plaintiffs. It was mailed out. I did it.
The problem that we have with the motion, and court's prepared to rule on that motion, is that the court rule provides 28 days for the time to answer, and the answer is deemed to be done when it is served, that is by first-class mail or personal delivery. And in this case, there is on behalf of the defendant, answers to the interrogatory with a certificate of service inside of 28 days from which the request for admissions were issued. The motion for default judgment must therefore be denied. I don't have to get into the question of whether 603 is the appropriate rule or not, because the request for admissions were timely served.
Your Honor, where's the what is that based off of? Because we would like for the defendant to show his actual evidence of serving it. Like there's no proof of service or filing. And then even on that, the only documents we received was with his motion to compel, which included the answers that he claims he sent, but even in that, it's not notarized. And according to the court rules, it's also deemed admitted when the documents are not notarized and it was not done under oath and there was no verification for the documents that he included in his motion to compel. So the motion to compel is the first time we saw any form of answer, but even then there's no notary, it's not notarized. And so that is actually a violation of the statute and also provides for the request to be deemed as admitted.
Mr. Cox?
Your Honor, there is no requirement for responses to requests to admit to be notarized. There is a requirement for interrogatories to be sworn to, not notarized anymore after the changes to the discovery court rules. The interrogatory responses that were attached to our response and that were served on the plaintiff, in fact, were verified by Erica White, the authorized signer on behalf of the defendant.
Okay. The court, I'm convinced Mr. Cox's interpretation is appropriate. It's what the court rule says. Your motion for default judgment must be denied. Now, is there anything you wanted to move forward? Anything else on behalf of the plaintiffs?
Your Honor, so just to clarify, what is the court basing the service on?
I find that the requests for admissions, which are the basis for your motion for default judgment, were timely answered.
When were they answered?
Excuse me.
Okay.
I find that they were timely answered, and therefore there's no basis to deem them admitted. There being no basis to deem them admitted, there is no justification for a default judgment. Thank you. I've ruled. You have absolute right to appeal my decision, but that is my ruling. Is there anything else you want to bring to the court's attention today?
Yes, in there, we also had a motion for a protective order to prevent a defendant from harassing us, undue burden. He has sent a number of motions to compels, even though if you look at our responses to the request admission is thoroughly answered. And we've gone through each of the request admissions and the interrogatories and have thoroughly answered it. But this is the second time I think that the defendant has requested a motion to compel for things that we've already answered thoroughly. And also, Your Honor, we would ask that if the defendant, because again, we have not received the answers to our request to admission. So if the defendant can either file that in the court or resend it to us, like there's no proof of filing or service only based on what he says. There's no actual documentation of that. And so we haven't actually received it. So we're also asking the court to request that he do that so that we have
let me stop right here. I have made my ruling in regard to the request for admissions. If you disagree with it, you may file an appeal. I would suggest you read the pleadings filed on behalf of Mr. Cox, which included, among other things, his answers to the request and a certificate of service of the same answers. Now, Mr. Cox, you had a motion concerning discovery, and they have filed responses. Are you satisfied with those responses?
I am not, Your Honor. So this is actually the second time that we've had to file a motion to compel. We filed our first motion on or about April the 19th. And I think about a day before we were scheduled to argue that motion, they did in fact submit responses. The first motion was premised solely upon the absence of the response at all. Now that we've had an opportunity to review those responses, we've filed the motion that's before the court today, asking the court to compel further, more specific responses with respect to the requests and their interrogatories. And as I've laid out in my motion and briefly summarized, we asked 11 document production requests, including documents supporting their claims for damages, and we got nothing. Literally not a single document was produced. We asked a number of interrogatories that asked for details about what witnesses they have or are aware of, what inspections they performed, what representations they alleged that the defendant had made, and damages that they alleged to have incurred. And they didn't give us any of those responses. And while they did give some very thorough responses to a couple of the interrogatories, they were not responsive to the other requests. And they didn't place a proper objection on those responses at all. So we'd ask the court to compel them to provide full and complete responses to those document production requests and interrogatories within a reasonable period of time.
Were any documents provided in response to the notice for production of documents?
Yes, because the majority of the documents that the defendant requested, we have already provided it in our original pleading, which included.
That's not the way the rule works. The way the rule works is that if they ask for production of specific things, you are supposed to provide those things in response to the notice for production of documents.
We did provide some document. We provided the documents that we had, and even in our answers, we said we provided all the documents that we have in our possession at this time, and we will make it available to the court on a rolling basis. That's what we responded to. We were not we were not fighting the discovery. And then we also named that some of the documents that are requested are already in the defendant's possession, and that it would be unduly to reprint the things that they already have.
Okay, well, let's stop right here in that regard. This is a lawsuit that you brought. They're empowered under the court rules to defend the lawsuits using, among other things, requests for production of documents, requests for admissions, and interrogatories. And I don't understand the argument that something that you claim that a document that's going to be used at your trial is too burdensome for them, for you to produce.
Oh, well, that's because
what
he
I'm-
asked for a very broad, he asked for any and all documents from the whole last 5 years. And so we said we already supplied the documents that are relevant to the last
All
2
right, this
years.
is, this
And
is
that would
what I'm,
take time for us to find those documents, where pro se documents. So we have provided a lot of the documents he requested, we provided it. You know, if you actually look at their request.
all right, let's stop right here.
Mhm.
Mr. Cox, you will draft an order adjourning your motion to compel until June 27th at 11 o'clock. You will draft another order denying the plaintiff's motion for default judgment for the reasons set forth on the record. I am going to give you an opportunity, plaintiffs, to supplement your production of documents, interrogatories, should you choose to do so. If you don't choose to do so, then I'll move forward. But you've told me that you have not provided a number of documents that he requested in his notice for production of documents.
Right, we've provided some of them, and the other ones we said we would provide it when they become available.
But they haven't been provided. That's the point I'm making.
Right, yeah. So, but
So
I'm just.
let me tell you how.
Properly. We
Let me
responded.
tell you how this is
properly.
going to happen.
Mhm.
You're not understanding me. You brought the lawsuit. You have an absolute right to do that, but they have a right to defend. They have a right to use the tools under the court rules, and the court rules provide they can say, show me the documents. So what I'm going to do is I'm going to adjourn to give you an opportunity to provide the documents, supplement your responses. Because when we come together again on this, if you haven't provided the documents, I'm going to have to move in another direction here.
Right, Your Honor, and I would actually request the court to really review our request. I'm not sure if you went through our responses, but
I spent my holiday reading this.
Okay, thank you. So we included a lot of the documents that we have, and we're actually in the process of getting inspections. We're in the process of getting a lot of the documents that they requested. So we're not trying to fight or combat the discovery. In fact, I think it's the defendant who's trying to combat the discovery because they actually haven't really responded or done anything. So
okay,
I appreciate your time for reviewing our documents.
That's what the taxpayers pay me for. So, Mr. Cox, do you understand the court's orders?
I do, Your Honor.
2 orders. Now, the next time we're together, given that discovery is closed, and given that there's been an opportunity to supplement any, how to say this, perhaps omitted unintentionally documents, I'm going to be very, very forward and strict on this. We're either going to have compliance or we're going to have sanctions. That's the way it's going to be. Now, what I would urge you all to do, and again, I can't order you to do anything. I would urge you to consider. Yeah, let me ask one more question. What has happened on the landlord-tenant case? All I need to know is, has it been concluded or not?
It has been concluded, Your Honor.
Okay.
It's being appealed currently. So there's actually
there's been an order.
There's a bond placed on the landlord tenant pending the appeal.
What was the order of the court? Possession for the defendant?
Yes, sir.
All right. Okay, so that matter is closed out.
There's a bond pending the appeal, so it's actually being appealed in the.
It's really that was just an information for me because as I indicated, as I earlier declined to consolidate the cases, the court has a landlord-tenant division, and in that we bifurcate frequently 2 things: possession, which is all, as I understand it, was decided in the landlord-tenant matter, and any claim for money damages, which is where we are on this file. So we will be together next June 27th at 11 o'clock. I'll be looking forward, Mr. Cox, to your orders.
I'll have them over.
Accomplished today.
Thank you very much, Your Honor.
Your Honor, I do have something to say, if that's okay, please.
Identify yourself, please, and please say what you want to say.
Yes, my name is Adidiong.
Okay, please say what you want to say.
Thank you. Yeah, so just to summarize something, this is not to really change your opinion because you have definitely shared your opinion and we've heard you. But just to say some things for the record, you know, as the court person is taking the court transcript. So as of today, May 30th, we have provided overwhelming amount of evidence to show retaliation and harm and harassment, right? We have court registers, proof of services, we have pictures. Plaintiff has even, defendants have left us to our proofs even. We've showed ample evidence, different leases. We have shown pictures of the home. We have shown email correspondence with the defendants and us. We have shown many evidence. The only evidence that Aaron has submitted to us as of May 30th to us in our home and even to the court records is the 2019 to 2020 lease, or sorry, 2021 to 2022 lease. That is the only evidence Aaron has ever submitted from the
All right, let's
beginning.
stop right here.
to this
This
end.
is, excuse me.
Aaron is being
Excuse
given
me.
the power to
Stop, please stop talking.
rewrite laws.
Please stop talking. I would like to avoid muting you. You will refer to him as Attorney Cox. or Mr.
Attorney
Cox.
Cox has also harassed us, right? That's why we had the motion for protective order, because he continues to harass us. He continues to oppress us in violation of court rules when we continue to supply ample evidence. The evidence we have given to him surpasses the evidence he has given to us or the court. And so just wanting that to go on the record, right? Because yes, we have multiple court cases and multiple investigations because we are being harmed
Don't fade
and
away.
oppressed.
Keep talking close to the mic. You're fading in and out because you're moving away from the mic.
Well, I hope the court recorder was able to write those out in the transcripts.
Now, just so you know, there is no court reporter. This is a jazz recording. It is a multi-track recording, which occurs, which every time one person speaks, they're put on that one single track. So there's a track for you, there's a track for Mr. Cox, there's a track for each of the plaintiffs. So when if you decide you want a transcript, there won't be any of the blurring that you frequently get with court reporters when several people trying to speak at once. We're on the JAV system and have been all the time. Anything else anyone else want to say?
Fine. It's still being recorded and we'll try to get the transcript, but we'll also still argue it in the appeal for sure. Like, because definitely we have ample evidence. We have supplied to Aaron Cox and proof of that evidence, and he has supplied no evidence whatsoever and also has answered to our stuff late. And that is in the receipts that we have provided to you over and over again, and that we have, and that we will continue to produce, right?
All right. Your appeal is not of my decision, because now you have an absolute right to appeal any decision I make, including the two decisions I've made today. But your appeal is as to whatever it is that happened or did not happen in the landlord-tenant division. All right, we'll talk to everybody again, June 27th.
We just want to, one more thing.
Please.
Yes, so, in the pattern of what we've been discussing around the unfairness and the inequality and the injustice of this court, just want to reiterate that my co-plaintiff said that the only thing that Attorney Cox has ever supplied has been a lease. And we believe that you're actually unfairly ruling and that there's actually some unfairness going on. There's a lot of rules that we have mentioned today and mentioned in our briefs that continue to be disregarded before this court. And we just want to, again, put that on record that we are being treated unfairly. We are pro se plaintiffs. Aaron Daniel Cox is being paid hundreds of dollars an hour to represent defendants and continues to, and has a whole law firm of people who are researching, who are supplying things, and he's never to this day filed a proof of filing. It's required by this law, by the court, to file a proof of filing, but you're basing things based on his words. But he will not file a proof of filing before this court. Everything that we have filed and gone before this court and filed a proof of filing so that we can say, actually, it was served on this day. We're not just depending on our name and our say as an attorney or as a man or as a white person, but actually we're adhering to the decisions of this court and the laws of this court. Aaron, Attorney Cox has never filed a proof of filing, but you have said today that you accept his word, even though we have ample evidence to demonstrate that what he's saying is false.
What I did, I accepted.
Provide that you are being unfair and unjust before this court, and we will continue to bring justice to this court because justice needs to be provided in this court. We cannot deal with discrimination. We cannot just deal with retaliation. We cannot deal with these things that we're dealing with today. Attorney Cox has continued to oppress us, has continued to unduly burden us, has access to print things multiple times over and over. We do not have money to print things over and over time, but he does. And now you're asking us to provide things that we have already provided before this court. It's very unfair, Judge Robinson. It's very, very unfair. It's very unfortunate. We are facing displacement. We're facing retaliation. We're facing discrimination. And this is even more adding to our unfairness. We have to, this is very unfair. This is very, very unfair. It's very unfair. It's unjust.
All right, I understand your objections. Again, you have an absolute right to appeal any decision that I make. And I would further point out for the court rules that the court rules apply equally to plaintiffs and to per se defendants.
But they have not.
So, excuse me, don't interrupt me again. I would further point out that at least on one occasion, you told me that you were an attorney licensed to practice law in the state of California.
In DC, I was once licensed in California, but my first introduction to the state of Michigan is facing an eviction. So I just got here. Now I'm having to eviction. It's very unjust. So I'm studying.
I understand you object. And again, you have an absolute right to appeal any decision that I make.
Absolutely. And we have absolute right also to
interrupt me again.
Unjust
right.
in this court.
I'm going to mute you now because I'm tired of being interrupted. If you are, as you say, an attorney licensed to practice anywhere, at minimum, you ought to have some understanding of courtroom decorum. So we will talk to you all again.
And I understand justice too.
Please do not interrupt me again.
You are using two different.
I'm going to mute you, ma'am. Thank you. We are on the.
I'm not a ma'am.
We are June 27th at 11 o'clock. Thank you all for coming in. We're off the record.
Thank you, Your Honor.
Read the court rules.
You're applying different court rules. You're applying different rules to Attorney Cox. There's no proof of filing. There's no proof of filing. There's no notary. There's no proof of filing. He hasn't done a lot of things, but y'all keep having side conversations and applying different rules.
Ma'am, we have.
I'm not a ma'am. I'm not a ma'am. That's part of the discrimination we're facing.
Plaintiff, we have.
You're applying different rules to Attorney Cox than you are to us. He has never filed a proof of filing before this court. He has no evidence about anything he's done. It's just his word.
I'm not going to continue this, but you should read the pleadings. He filed certificates of